Hello and welcome to today's Patent Eligibility and Section 101 Update live MBHB webinar. My name is Dave and I'll be in the background answering any WebEx technical questions. If you experience technical difficulty anytime during this WebEx event, please submit your technical issue in the Q&A panel at the right of the screen and I will assist you. Or you can call 1-866-779-3239. Please note that as an attendee you are part of a larger audience today. However, due to privacy concerns, the attendee list is not displayed. All attendees will be in a listen-only mode for the duration of today's call, and as a reminder, this call is being recorded. With that, we invite you to sit back, relax, and enjoy today's presentation. Now I'd like to introduce your first speaker for today, Michael Barella. Michael, you now have the floor.
Thank you, and welcome to our webinar on patent eligibility and all that's going on with Section 101. This is coming live from the MBHB offices in downtown Chicago. My name is Mike Barella, and we're going to get started in just a minute, but first I need to do some housekeeping. Please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note that there are two randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive the CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will attempt to address submitted questions at the end of the webinar. If time does not permit, we will respond offline after the webinar, and thank you very much. So let's get started with a roadmap of what we're going to be covering today. We'll begin with an introduction of the current 101 framework on patent eligibility. Then we will focus on the case law, what has been going on mostly in the Federal Circuit over the last year or so throughout 2019. We will then move from the judicial branch over to the executive branch and spend some time discussing the U.S. Patent and Trademark Office's updated patent eligibility examination guidance, and in particular, how this is impacting examiners and the Patent Trial and Appeal Board, or PTAB. Then we will move on to the legislative branch and talk about what is going on, or maybe what is not going on, in Congress with respect to Section 101 reform. And we will finish up with some recommendations that we have for best practice in light of all of we've discussed. So let's just begin with a Section 101 background. And this background is really meant for those of you who are not practicing patent law every day. Patent attorneys, people who deal with Section 101 probably already know all of this, so you can tune out for about 3 or 4 minutes while I give the background for a number of people on the line who may be more on the business side or maybe more general practice attorneys who are curious to learn about patent eligibility. So Section 101 of Title 35 defines the types of inventions that are eligible for patenting, and there are 4 types, fairly straightforward. Processes, articles of manufacture, machines, compositions of matter. If your invention falls into one of those 4 categories, it can be patented, or at least it's statutorily eligible for patenting. All right, these are very broad categories, and it's hard to think of too many things that don't fall into one of these categories. Data is one example of that. Data is not one of the 4 statutory categories. But not so fast. We have the 4 statutory categories, which are quite broad, but we've also got the judicial exceptions, which eat away at these categories. So there are 3 judicial exceptions that have been defined over the years by the Supreme Court: laws of nature, natural phenomena, and abstract ideas. And if your invention is directed to or is involving a law of nature, natural phenomena, or abstract idea, then it may be ineligible for patenting even if it falls into one of the 4 statutory categories. So you have to pass both the statutory test as well as the judicial test. And speaking of these tests, if you take a look at the flow chart on the right, this is a combined view of the statutory and the judicial parts of the test. So step 1 of the flow chart is the statutory test. You ask, is the claim directed to a process, machine, manufacture, or composition of matter? And if the answer is no, then you're done right there and your invention is not patent eligible at all. But if the answer is yes, then you have to go through the 2-part judicial test. Now, this 2-part test was defined over the years by the Supreme Court, and in particular in 2012's Mayo versus Prometheus, and then again in 2014's Alice versus CLS Bank cases, they've set forth these two parts to the test. They're also called two prongs, and here they're called Step 2A and Step 2B. I'm going to use all those terms interchangeably just because that's the way we tend to talk about these parts of the test. But in any event, if you pass the statutory Step 1, then you find yourself in Step 2A, which is Part 1 of the Mayo-Alice test, and you ask, is the claim directed to a law of nature, natural phenomena, or abstract idea? If the answer is no, then you're good. Your claim qualifies as eligible. But if the answer is yes, you need to further analyze that claim to determine whether it recites additional elements that amount to significantly more than the judicial exception. All right, so why do we do this? Well, just going back to the flow chart here, it's a matter of policy. The Supreme Court doesn't want anybody to go and try to take a law of nature, for example, or a natural phenomenon such as the Pythagorean theorem and take it out of the public domain and bring it into a patent 20-year monopoly. And so there's a good policy motivation behind this. But what we'll see is, as we go through this presentation, is that a number of these terms, such as directed to and significantly more, don't have clear interpretations in the case law, and that has caused many, many issues to arise. All right, so having mentioned the case law, let's move on to a case law update. This, as I mentioned earlier, is going to focus on the Federal Circuit. There was not much, if any, 101 activity in the Supreme Court except for the court reviewing petitions for certiorari. So this is a bit of an eye chart, but it is a complete list, as far as I can tell, of all Federal Circuit 101 decisions during calendar 2019. And there's a total of 25 of them. And there's two things to note. First of all, the judicial exception column, which is the second from the left, but kind of in the middle, you'll note that most of the judicial exceptions that are at play in these cases are the abstract idea exception. There's some natural phenomena, some law of nature cases, but for the most part, the majority of the case law is focused on the abstract idea exception. It's one of the more, of the three, I think it's clearly the most confusing to apply in practice, and so we're going to spend a lot of time focusing on that. We will discuss one law of nature case, though, just for kicks. And then the other thing to note is that I've marked these cases either as black or with red, and the cases marked in black are the ones where the Federal Circuit found the claims at hand to be not eligible, and the ones that are marked in red, the claims were either found eligible or they were remanded back down to the district court for further consideration. And we'll see that just looking at this chart, the odds are about 1 in 5 of all things the same, of a case going to the Federal Circuit on a 101 appeal, that the claims in that case will be found to be eligible. And that ratio, that percentage of about 1 in 5, 20%, has been pretty consistent over the last several years, since about 2016 or so. So what we're seeing is that there's not much of a change in how the Federal Circuit is viewing Section 101 just from a pure statistical point of view. If you take a 101 case up to appeal on the Federal Circuit, there's a pretty good chance that you're going to lose. So with that happy note, let's move on to 5 cases coming out of the Federal Circuit that we're going to discuss. And poor attempts at humor aside, I'm going to break them into 2 categories. One, the first category is the SRI versus Cisco and KPN versus Gemalto cases, which were both found to be patent eligible. And then we have 3 cases below that, which will come later, ChargePoint, Chamberlain, and American Axle, which were all found to be ineligible by the Federal Circuit. And in particular, I picked the ChargePoint, Chamberlain, and American Axle cases because they're all considered to be very controversial decisions. And there's even a pretty lengthy dissent in one of them. And on top of that, some of these cases have also even been brought up by members of Congress as being examples of why Section 101 is so hard to apply in practice and why reform is needed. So with that in mind, let's move on to our first case, which is SRI versus Cisco. And for all of these cases, I'm going to present you with a claim, an example claim on the right. We're not going to go through it in detail because we don't have enough time to analyze the claim in that level of detail, but I'm going to describe it to you at somewhat at a high level so you have an idea of what the invention is about. I'll give you a figure on the left, again, more for your reference than anything else. So what is this claim about in SRI? Well, in computer networks, anomalous activity is generally considered to be a bad thing. Anomalous activity might be hackers trying to get into your network, software that's downloaded on machines in your network, trying to deploy viruses, or maybe just something that the system doesn't understand, has never seen before. And you want to have a system, you want to have the monitors in your network to detect when anomalous activity occurs and let you know as soon as possible. And the invention here is related to deploying these network monitors out to the edges of the network, so to speak, and then the network monitors will detect suspicious activity or anomalous activity by looking at data packet transfers, errors, data volume, various types of requests and responses, and so on. And then from that, they will generate reports, and then these reports will be aggregated at a higher level monitor in a hierarchy of monitors. And so these higher level monitors will put together more of a global picture of what's going on in your network based on the individual units of data that are collected. So all of that sounds good. That's the invention. So this case goes to the Federal Circuit, and the majority opinion found that the claims are in fact eligible. And there was since there was a majority of 2 judges, that means in the Federal Circuit with a panel of 3 judges, you also have a dissent, and we'll get to that in a little bit. But the majority found in particular that the claims recite a specific process rooted in computer technology that uses network elements to monitor and analyze specific types of network data. Now, I'm highlighting the word specific here because that seems to be a keyword that is just throughout these 101 cases. When the Federal Circuit starts writing an opinion and they describe the claims as being specific, that is usually a sign that they're going to find those claims to be eligible. And when they complain that the claims are not specific, then that's a sign that they're going to find the claims to be not eligible. And so ultimately they found that these embodiments solved a specific problem arising in the realm of computing. And on top of that, the court also looked to the specification. So they didn't just look at the claim, but they looked at the specification. Now let me flip back to the claim for a second. If you really look at this claim and you kind of, read through it carefully, all it is covering on its face is detecting some network activity, generating reports, and then feeding those reports up the hierarchy. This is a fairly broad claim. So why did the Federal Circuit use the word specific to describe the invention? Well, that's because they looked to the specification, and the specification did a pretty good job of selling the invention because the specification described how conventional networks have problems with anomalous behavior and detecting it rapidly enough, and the invention provides a framework for recognition of more global threats to interdomain connectivity, and had a number of other beneficial features. So according to the court, the claim is not directed to an abstract idea or any other judicial exception for that matter, because it specifically solves a technical problem that was identified in the prior art. All right, but as I mentioned, there was a dissent, and this dissent is from Judge Lurie, who has never really been a friend of software or business method patents. And what he did is he invoked this case, Electric Power Group. And Electric Power Group was a 2016 case coming out of the Federal Circuit, which stood for the notion that if you have a claim that is only directed to gathering data, processing data, and spitting out results, that claim is almost inherently going to be not eligible. It's going to fail the Section 101 test because it is too abstract. And here he found that the claims in SRI were virtually indistinguishable from a 101 perspective from the claims that were held ineligible in Electric Power Group. And he disagrees with the majority about the specificity of the claims. He actually says that the detecting of suspicious activity based on the analysis of traffic data is there, but the claims add nothing concerning specific means for doing so, and there's no specific technique described for improving network security. So he didn't find the claims to be specific at all, and he also criticized the majority's reliance on the specification, and they said, and he indicated that the claims should be read as the more on their face, and you shouldn't read the specification into the claims. So what we see here are two threads that are going to be running through virtually all of the 101 cases that we discussed today. Number one is this question of how specific the claims are, and then the second question is how much importance do you put on the specification versus the claims themselves. And as you'll see, the Federal Circuit judges tend to disagree with one another on both of those points. All right, so let's move on to our next case. This is KPN versus Gemalto. And the invention here has to do with error-correcting codes in computer networks. So when computers transmit data between one another from a transmitter to a receiver, almost all the time, this data will be protected by what's called an error-checking code. And the idea is that the data can be corrupted during the transmission process, let's say over a wireless network, and when it arrives, it's going to look different than when it was sent, and that's usually not a good thing. And so if you have an error-detecting code put into the data that follows the data or comes along with the data, the recipient can at least determine that there is a problem and then decide what to do. It might just say, okay, fine, I'll take the data even with errors and I'll accept that risk, or the recipient might just discard the data, ask for a retransmission, or what have you. Now, what the inventors here noticed is that there are certain types of what they call systemic errors that happen in networks where the errors are not random, right? They're not just Gaussian noise type errors, but they happen on a consistent basis from block to block. So the errors repeat. So the same bits of the same blocks are going to be corrupted each time. And as it turns out, static checksums, which are what the prior art teaches, don't always do a good job of detecting these errors. Static checksums work fine with Gaussian noise type errors. They do not work well with systemic errors. So the invention here involves varying how you do the checksum. You vary it based on time, based on content of the original data, or certain other factors. Now, taking a look at the claims on the right, Claim 1 was not actually under dispute. The appeal was only focused on Claims 2 through 4, which are all depend in one way or another back to Claim 1. So that's why we have all 4 of the claims here. The court, well, going back to the district court, first of all, the district court ruled that the claims failed the Alice test, and here we go again, a lack of specificity. In particular, the district court judge complained and said that, look, the claims do not say how the data is reordered, how to use the reordered data, how to generate additional data, how to use additional data, or even that any data is transmitted. So that goes up on appeal to the Federal Circuit, and the Federal Circuit here, this panel disagrees, and they said that, no, this invention is directed to a non-abstract improvement to an existing technological process, and in particular, looking at Claim 2, the court stated that Claim 2 recites a specific implementation of varying the way that check data is generated, and that this specific implementation improves the ability over prior art error detection systems. So again, the court is looking for specificity in the claim, and it's also looking for an improvement over the prior art, and this notion certainly was supported by the specification of the patent as well, although we don't get into that here. So once again, the court finds that these claims are not abstract, they satisfy prong 1 of Alice, and we're done. So we have 2 cases now where the patentee won on prong 1 of Alice. We didn't even get into prong 2 of Alice, the significantly more analysis. But that's about to change, because we're going to get to ChargePoint versus SemaConnect, and this is one of the first one of 3 cases where the claims are found to be not eligible, and we'll see the difference between an eligible claim and an ineligible claim called out here. So the invention here has to do with electric car chargers. Now, for anybody who has an electric car, first of all, congratulations, but second of all, you'll probably notice pretty quickly that the biggest problem with electric vehicles is range. You only get about 200 to 300 miles out of a charge. So what do? Most of us who have electric cars leave them plugged in our garages or overnight, or maybe we plug them in at work if we have car chargers at our employer, and we keep the car charged up that way. But this doesn't really scale very well. If you want to drive your electric car cross country, well, that's just not going to work. But one of the things that the inventors at ChargePoint figured out was, well, a lot of people leave their cars in certain locations for a period of time, and during that period of time, those cars could be charged. So, for example, if I'm going to the shopping center or to the mall, I might be there for an hour or so. If I'm going out to dinner, I might not be there for an hour or two. A movie theater, I might be there for a couple hours. Why can't we have charging stations at all these locations? Well, to do that, you need to control how the electricity is getting distributed to the cars, and in particular, you want to be able to charge for it. So the invention involves an electric car charger that you can control from an app on your phone, and it's controlled over the network. And looking at the claim language, we've got a control device that turns on or off electrical supply. We have a transceiver that communicates requests from this application ostensibly to the control device, and we have a controller coupled to the control device and transceiver that causes the control device to turn the electrical supply on based on communications from the remote server. So the way I tend to look at this is that if I plug my car into one of these public charging stations, I fire up the app and I select charge, and it asks me for my credit card number, and I put that in, and then I spend a few dollars, but I get to charge my car while I'm shopping or eating dinner. So that's all well and good. What happened in the Federal Circuit when they reviewed this claim? Well, they very rapidly, the court very rapidly determined that the claims involve an abstract idea. Now remember, prong one of Alice is whether the claims are directed to an abstract idea. And all of these terms are not very well defined. But what the court said here is that it's clear from the language of Claim 1 that the claim involves an abstract idea, the idea of communicating requests to a remote server and receiving communications from that server. So here the court takes a very counterintuitive, in my opinion, approach, and they say that communication over a network is an abstract idea. All right, well, be that as it may. The court goes on to say, well, but what we really want to do is determine whether the focus of the claim is an abstract idea. So here, this court, or this panel, is applying prong one of Alice in a fairly interesting fashion. They're almost dividing it up into two parts, and they're saying that to determine whether a claim is directed to an abstract idea, you have to figure out whether it's focused on the abstract idea. None of this is in the case law previously or in the statute, so we're kind of in terra incognita with this particular panel's version of the test. But nonetheless, the court goes on to state, kind of interestingly, that the problem described by the specification, so they are looking to the specification as well as the claims, but this problem is an abstract idea, or it addresses an abstract idea because they view the problem being solved is a way for charging stations to communicate over, or to be communicated with over a network, which improves them from a business perspective, right? Which, again, is kind of an interesting way of looking at this invention. You would think if you look at the claim, it seems clearly technical. It involves electricity being turned on or off, but the Federal Circuit looks into this and they dig a little deeper in the specification. They say, no, you're solving a business problem. You're not solving a technical problem. And so, as a result, they held that Claim 1 is in fact directed to an abstract idea. All right, then they and I want to point out some fairly problematic language here, at least in my opinion. There's a statement in this case, communication over a network for the purpose of device interaction, I'm paraphrasing a little, has been and continues to be a building block of the modern economy. So they seem to look at communication over a network potentially being per se an economic solution to an economic problem and therefore an abstract idea rather than a technical improvement. Which I think is incredibly problematic because communication over a network is clearly a technical endeavor for anyone who's actually tried to set up a network or get applications to communicate over it. You will know that. But in any event, we move on to prong 2 of Alice for the first time. This is step 2B of our flowchart. And ChargePoint tried to argue that there are numerous inventive concepts that would be significantly more. In particular, the network-controlled charging station, the charging station that receives communication from a remote server. But the court didn't buy into any of this, and they said all of these features are not significantly more. They're just ways of involving network control, and that's just another abstract idea. So in other words, all of these purported inventive concepts that ChargePoint came up with, the court dismissed all of them and saying you're just adding more abstract ideas onto the abstract idea that we already identified. There is no inventive concept of this claim, and you lose under Alice. And that is the end for ChargePoint. Okay, so we are at our very first WebEx tracking poll. If you would like CLE credit, please enter the word abstract into the WebEx poll interface on your computer. You don't have to enter it in capital letters. You can enter it in lowercase letters. In fact, you can enter anything that looks like the word abstract, and we'll probably just give you CLE credit anyway because that's what we'd like to do. So please take a few seconds to take care of that, and we'll take a maybe 30-second break at most, then we'll move on to our next cases. Okay, I realize that was a short 30 seconds, but we have a lot to talk about, so let's just keep going. And after all, it's only one word I'm asking you to put in there. It shouldn't take too long. All right, the next case is Chamberlain versus Techtronic, and this is another case where we have a physical device, in particular a movable barrier operator, and otherwise known as a garage door opener. And the invention here involves a garage door opener that has a wireless status condition data transmitter, right? And the way I like to think about this is if you're anything like me, you pull your car out of the garage, you start driving down the street, you get around the corner, and then you think to yourself, did I really close my garage? And a lot of times you just turn around, you go back, and you find out 99% of the time, yes, I did in fact close my garage. Wouldn't it be nice to be able to have some sort of way of looking at your phone and figuring out the status of your garage door? Is it open or is it closed? You can even use that in your house. Sometimes you're going to bed and you're wondering, oh, do I need to go check the garage door? But if you've got an app that's going to give you its status wirelessly, then you don't need to actually get out of bed and do that. Anyway, the claimed invention here involves a controller having a plurality of potential operational statuses. So, for example, with our garage door, that could be open, closed, maybe something in between, who knows. A movable barrier interface. Now, that's not the movable barrier itself. That's not the door itself, but it's just an interface to talk to the door. And a wireless status condition data transmitter that we mentioned before that will tell you whether the door or movable barrier in this case is open or closed. All right, sounds like a useful invention. Goes to the Federal Circuit, and the court finds the claims to be abstract, not just based on the language of the claims themselves, but also based on the specification. And the court very quickly determines that Claim 1 is directed to an abstract idea of wirelessly communicating status information about a system. So there seems to be this thread going through this case in ChargePoint about how data communication, communication over a network, is really not anything particularly technical. It's an abstract concept, which, again, for those of us who have worked in that business, that just seems a bit strange. Anyway. The invention is not limited to specific implementation of a technological improvement. So there's our friend, the word specific again. And as soon as you see the court saying that the claims are not specific, then you know that those claims are in trouble. The court looked at the specification and saying that the only described difference between the prior art and the claimed system is that the status information about the system is communicated wirelessly. So this is a very, very interesting prong 1 of Alice analysis. Now, if you go back to 2016, we had a couple of Section 101 cases decided by the Federal Circuit, Enfish and McRow. And in both of those cases, the panels that wrote those decisions went at great length to explain that under prong 1 of Alice, you must consider the claim as a whole. You can't just divide it up. But that's exactly what this panel has done, because all they care about is the delta, the difference between what's being claimed and the prior art. And they look at that delta, which is the wireless status communication, and they say that, well, that delta, wireless status communication, that's just an abstract idea. They do not consider the claim as a whole. They just look at the part of the claim that, in their view, is what goes above and beyond the prior art. So another thread that we'll see through these Federal Circuit cases is that nobody really seems to agree on how to apply any of these tests, whether it's the prong 1 test or the prong 2 test, either step 2A or step 2B. It just is not a lot of consistency going on. The other thing is that you might be thinking to yourself, well, hey, wait a second, why are we spending so much time worrying about prior art? This is Section 101. We've got Section 102 and Section 103, where those are the parts of the patent statute that are fairly well understood, and they both address prior art concerns. Well, Section 102 and Section 103 have been shoved unceremoniously into Section 101 to the point where if you carry out a Section 101 analysis, you're almost carrying out a de facto Section 102 or 103 analysis. And we'll talk about the same thing for Section 112 in a little bit as well. All right, we don't have to like that, but that's just the way things are. Looking at the specification, the Federal Circuit also decided that it doesn't help provide an inventive concept when it moves on to prong 2 of Alice, and in particular, the court looks at the elements, the additional elements of the claim, apart from those parts found abstract, and determines that they involve well-understood routine or conventional activity, and that's not significantly more under the prong 2 of Alice test. And so the claim ultimately fails and is held to be ineligible, not passing the 101 barrier. Well, finally, in perhaps our most interesting case of this bunch, we've got American Axle. And this invention is directed to tuning a drive shaft liner so that that liner can attenuate at least 2 different types of vibration. Right, so if you know anything about drive shafts, and I'm really not an expert here, but my understanding after reading this case is that there are at least 3 types of vibration, bending, torsion, and shell modes, and that in the prior art, different types of liners can be used to address or mitigate one of those types of vibrations at a time. But here the invention is to have a liner that attenuates at least 2 types of vibrations. And if you look at the second element, or excuse me, the third element of the claim, the one at the very end, it goes into a fair amount of detail by stating that the shell mode vibrations, it's going to damp the shell mode vibrations in an amount that's greater than or equal to about 2%, and it's also going to damp bending mode vibrations by being tuned within about 20% of a bending mode natural frequency. So there is some specificity to this claim, but if you look at the claim and kind of take a step back, it's not describing how to achieve these goals. It's just claiming the goal and not the process to get to that goal. And as it turns out, that is a big problem for this claim. Nonetheless, the majority goes on to, first of all, observe that it's well known in the prior art to alter the mass and stiffness of liners to alter the frequencies to produce damping. Okay, so that's one strike against the claim. And also, the majority determines that the selection of liner frequencies for such attenuation are obtained by applying Hooke's law. And this is kind of interesting because the claims do not invoke Hooke's law, and as far as I know, the specification doesn't either. But this is something that the court came up with on their own, probably prompted by the defendant in this case. And so they find that Hooke's law is a natural law, and therefore the patent claims are not describing a specific method for applying Hooke's law in this context. They simply state that the liner should be tuned to dampen certain vibrations. And this gets back to what I was saying just a little while ago, in that the claim doesn't really tell you how to get to the outcome, it just claims the outcome. But having said all of that, this whole notion of invoking Hooke's law and looking at the difference between what's being claimed and the prior art and only considering what's different, again, seems to be a representation of how the prong 1 test is supposed to be carried out, at least if you look back at how it was carried out in EnFish and McRow by the Federal Circuit just a few years ago. In any event, so the court finds that the claimed advance is simply the concept of achieving a result by whatever structures happen to work, and that means that the claim is just abstract in this panel's point of view. And then going on to prong 2, the panel just very rapidly throws away all of American Axle's prong 2 contentions, where American Axle argues that there were numerous inventive concepts in the claim, and the court just throws them out with very little discussion. So since we have a majority, we also have a dissent, and we have a dissent from Judge Moore. And if you're a fan of the Federal Circuit, you will know that Judge Moore tends to write some very scathing dissents from time to time. I happen to believe she's probably one of the sharpest judges on the Federal Circuit, and when she writes a dissent, you do need to pay attention because more often than not, she's got some really good points. And in this case, she blasts the majority and states that they just parrot the Alice-Mayo test and reduce it to a single question of whether a claim is directed to a law of nature. She's also deeply troubled because she believes that the majority disregarded the second part of the Alice-Mayo test, and because there were a number of inventive concepts proposed by American Axle that were all dismissed, and she accuses the majority of repeatedly misrepresenting the record, which is a pretty harsh thing to say about one's colleagues. She goes on to state that the majority was really applying a Section 112 analysis in the guise of a 101 analysis. And so here, once again, we're seeing this munging together of different parts of the patent statute. We talked about it before, where Sections 102 and 103 are intended to be the sections under which prior art is considered, but that has been stuffed unceremoniously into Section 101, and now we have Section 112, enablement written description, also being stuffed into the 101 analysis. And she writes that we cannot convert 101 into a panacea for every concern we have about an invention's patentability. And, you know, this is a point that a lot of us have been making ever since Alice came down, is that Section 101 is being expanded well beyond its intended scope by the application of the Alice test, because now you can do a prior art analysis under Section 101, and you don't have to do fact-finding. It can be done as a matter of law. You can do a Section 112 analysis without considering what one of ordinary skill in the art would think, because it's stuffed into Section 101. So she's pointing out some long-standing problems with the Alice test, and she's doing so very, very strongly. She also argues that there were at least half a dozen inventive concepts in the claim that were in the specification that the majority just never even considered. Okay, so that's the Federal Circuit in 2019. Those are 5 of the 25 cases. These are 5 of the cases that I think are the most worth reading, but there's a handful of others that are pretty good too that we don't have enough time to go into. But very briefly, let's touch on what happened in the Supreme Court, and I'm going to cheat a little bit. I'm supposed to be talking just about 2019, but some really interesting things happened in the last several weeks in 2020. The Supreme Court had been sitting on a number of Section 101 petitions for certiorari, and over the course of about 8 days, it denied all of them. So it denied HB versus Berkheimer, which was a case a lot of people were watching. Same thing with Hickma versus Vanda, Athena versus Mayo, and our friend ChargePoint versus SemaConnect, which we just discussed a little while ago, that was also denied. So what this seems to be is that the Supreme Court is sending a signal that it really doesn't want to deal with 101. It has not taken up a 101 case in almost 6 years now since Alice came down. And it's hard to decide what that really means. I mean, it may be that the court just doesn't think any of these cases are particularly good examples of or good vehicles for clarifying 101, or the court might be thinking, well, 101 is working just as intended, and we like it the way it is, and we don't want to change anything. So we're just not sure at this point. But what I do want to point out is, if a case is not crystal clear from what I've said already, there are some significant problems with the way that the test is being applied today, and the Federal Circuit panels are not applying it in a consistent fashion. And that has led to all kinds of problems. So let's move from the judicial branch over to the executive branch and take a look at what the USPTO has been doing. And in particular, the USPTO updated its subject matter eligibility examination guidance 2 times last year, once in January and once in October. And the reason why it has done this is because, like the rest of us, the USPTO has struggled with applying Section 101 consistently since Mayo and Alice. And this is because, as mentioned, the Federal Circuit precedent is unclear and conflicting, and the PTO has recognized that. And so it's come up with its own test for patent eligibility under Section 101, which is similar to the one that the courts have been using, but it's a little bit different. And we'll talk about those differences in a bit. But one of the things that some of my more cynical colleagues might say is that it's gotten so bad at the Patent Office that the outcome of a claim being analyzed for patent eligibility may depend more on the examiner who is looking at it and that examiner's art unit than the merits of the claim itself. Right? I don't necessarily believe that to be the case, but I will tell you that different examiners use different standards and different art units use different standards, and this has caused a lot of problems. And I think the PTO has recognized that at least, that it's incredibly difficult to have 8,000 some odd examiners apply a test as confusing as the Alice test in a consistent fashion, and there's just way too much case law for examiners to digest. So having said all of that, the January update was a significant departure from the eligibility test that was applied by the courts. It came along with some example claims, and the October update, which we're not going to spend a lot of time on, was a relatively minor set of clarifications to the January update. So here's the big change. The January update added yet another step to the Section 101 patent eligibility test. So this is a modification of the flow chart that we looked at before, but here Step 2A is broken up into 2 parts, Part 1 and Part 2. So Step 2A, as applied by the courts, answers the question, is the claim directed to a judicial exception? But here, Step 2A, Part 1, asks the question, does the claim recite a judicial exception? All right, if the answer is no, then your claim is eligible. But if your claim does recite a judicial exception, you have to ask the question, is the judicial exception integrated into a practical application? And if the answer is yes, then your claim is eligible. If the answer is no, then you go on to Step 2B. All right, so let's see how that gets applied in practice. The other major change to the USPTO's, or that was invoked by the USPTO's guidance update, was the notion that all abstract ideas have to fall into one of 3 classes: mental processes, mathematical concepts, or methods of organizing human activity, mostly financial. So I tend to think of these as the 3 M's: math, money, and mental processes. Mental processes are concepts performed in the human mind. Mathematical concepts would be equations, formulas, calculations. And the largest bucket here is the method of organizing human activity class. It's fundamental economic principles, so you've got your Alice and Bilski type claims falling into this, commercial legal interactions, and managing personal behavior and relationships. And at first blush, you might think, well, it's good that the PTO is going to consider only 3 different types of abstract ideas, so they can't just pull anything out of the air. But in practice, these are very, very broad categories, and just about anything that you would think is that the courts would find abstract can also be found abstract here. So having said that, let's make a few observations about, we have about a year and a month of experience with this test, and in my view, and I believe it would be the view of most practitioners, is that examiners do seem to be taking the guidance seriously, and in fact, there's been many long-held 101 rejections being withdrawn in light of the guidance that happened early part of last year. Some of the issues that we see is that breaking Step 2A into 2 parts doesn't necessarily clarify the test all that much, and we see examiners applying very conclusory reasoning or trying to shift the burden of proof to the applicant during examination. And the way that this happens is that the examiner will give you a conclusory 101 rejection, and that does not establish a prima facie case of ineligibility, and then the examiner will say, well, now it's your job to prove to me that your claims are eligible. And in fact, it's not the applicant's job to prove that the claims are eligible. It's the office's job to establish that arguments for the ineligibility of the claims, which the applicant can then rebut. So that's a subtlety that a lot of examiners don't seem to get. And when you tell examiners that their reasoning is conclusory, they don't seem to understand what that actually means. So this is something that happened before the guidance. It's still happening after the guidance, and it's probably one of the more frustrating aspects of prosecuting 101 cases these days. Some of the example claims that were given in the guidance, and by the way, I think the example claims overall are quite good. I applaud the office for the amount of effort they put into it. But there are some really weird ones, and in particular, because you look under the office's test at whether the claims recite an abstract idea, it is possible to have a broader claim not recite an abstract idea and pass the test, and a narrower version of that same claim explicitly recite an abstract idea and fail the test. It's at least in theory possible for that to happen. I don't know how often it happens in practice, but it is kind of weird to think that you can narrow an eligible claim to make it ineligible just by throwing an equation into it. And I also want to reiterate that these differences between how the PTO handles the test and the original Alice test as interpreted by the courts can result in the PTO allowing patents to issue that can then be invalidated by the courts because the tests are different. And this is a problem, you know, I don't know if it's happened in practice yet, but I think it's almost inevitable that it will. All right, so one of the things I'd like to do is to take a look at how the test is being applied. This is the PTO's test, by the way, so the three-question test, or I should say 4-question test if you include the statutory questions, for Section 101 patent eligibility, how it's being applied by the PTAB. And what you'll see, if you look very carefully through the PTAB's informational decisions that it's published last year, is that there actually is a consistent thread. So the PTAB publishes precedential decisions, which are binding on other panels and examiners, and it also publishes informational decisions, which are not binding but hopefully helpful and should be followed to the extent that it's reasonable to do so. And it published last year 6 informational 101 decisions that all came out after the guidance, and they all apply the guidance. So let's dive into those. I'm not going to go into each invention in a lot of detail because what I want to see here is the overarching pattern, not so much the individual details. So ex parte Faust were claims that were found eligible. They were directed to optimizing the signal-to-noise ratio in a magnetic resonance tomograph. The claims recited equations, but were actually, if you look at them, they're very narrow and specific, and the specification pointed out drawbacks to the existing prior art systems. As described in the specification, the invention improves the sensitivity of the coils and improved image quality, which resulted in the PTAB ruling that even though we have claims that recite equations and therefore recite mathematical abstract ideas, they are integrated into a practical application because they are a technical improvement over the prior art. So these claims are eligible. Similarly, in ex parte Olson, claims were found to be eligible, and these claims are directed to transforming the coordinate system of catheter navigation into a coordinate system of an external model or external image data. Again, the claims recited equations but were fairly narrow and specific, and the specification indicated that the invention provides a technical improvement by avoiding errors introduced in the prior art. So, again, mathematical abstract ideas explicitly recited by the claims, but they were integrated into a practical application because they were a technical improvement over the prior art. You may be seeing the pattern already, but let's just continue. Ex parte Kimazuka, claims are found to be ineligible. This is an invention directed to software for selecting a golf club with a loft angle for a player based on data gathering from that player's hits. And the court found that, or the PTAB found that under broadest reasonable interpretation, the claim steps could be performed in the human mind. In other words, they were a mental process. And the court also looked to the specification and decided that golf club selection is a non-technical problem, and the claim does not improve anything about the golf clubs themselves. So, therefore, the claims fail under the practical or integration into a practical application test, and they also failed under prong 2 of Alice because all additional elements were just well understood, routine, and conventional. All right, but again, the emphasis it seems to be on the problem being solved. Let's take a look next at ex parte Savescu, software for creating a lifecycle workflow of a project. The PTAB here also pointed out the non-technical or business nature of the claim, finding that it was involving determining a project name, describing the project's purpose, describing the project's scope, among other things. Now, these are all important things in enterprise networking and enterprise applications, but according to the PTAB, this fell into the certain methods of organizing human activity, abstract idea bucket. All that was left after looking at that was a generic computer. So the PTAB determined that these claims were not integrated into a practical application because they didn't solve a technical problem, and also all of the additional elements were well understood, routine, and conventional, so the applicant loses under prong 2 as well. So at this point, I think you're starting to see what the pattern is amongst these cases, but let's just finish up with the last two. Ex parte Smith, this one is kind of an outlier. I think it's still consistent with the other ones, but it was the only of these 6 cases that had a dissent, so arguably it could have gone either way. The invention here is directed to collecting orders for derivatives in a hybrid derivative trading system. So immediately, I know what you're thinking, financial transactions, this is like Alice and like Bilski, and it's probably not going to be eligible. But it turns out that this claim was found to be eligible. The PTAB looked at the claim and decided under broadest reasonable interpretation, it did recite a fundamental economic practice, but it found that there were additional elements involving delaying an order execution, starting a timer, receiving a matching quote, allocating the order between market participants, and then executing the order based on the timer. And the majority determined that these additional elements were different from the conventional practice of automatically executing orders, and that was different enough to integrate the economic practice into a practical application. So we never have to get to prong 2 of Alice. The dissent, however, basically disagreed with all of that and said, well, timing features are not technical, they don't provide a technical improvement. But nonetheless, the claims were ultimately found to be eligible. And finally, our last of these 6 cases, this is our artificial intelligence machine learning case, something near and dear to my heart because I practice a lot in that area. And it was directed to a neural network speech recognition system that maps spectrogram frames to character probabilities to try to figure out the utterances. It makes spectrogram frames from your utterances and then tries to figure out what you're saying from that. The claims are actually kind of outcome-oriented, but that's almost required in certain types of machine learning inventions. And they were, however, they did have a fairly specific series of steps that they carried out. And here, the PTAB looked at the claims and said, well, first of all, they're not directed to a mental process because even though in theory they could be performed either in the mind or in pencil and paper, it's just so complicated to generate a set of spectrogram frames and obtain predicted character probabilities from a neural network that you can't practically perform these activities in the human mind. So in other words, if you've got a neural network that maybe has hundreds of nodes and it's going to be trained through thousands of iterations, yes, in theory, that's just math and it's all mental, could be performed mentally if you had a big enough brain, but it would still take you millions of years to come to an outcome. So there is no mental steps being practically performed in the human mind here. And also there was no explicit recitation of a mathematical concept. In other words, the invention involved an algorithm, but the algorithm itself was not recited. So there was no abstract idea in this claim, and the claim was found to be eligible. And the specification backed this up by indicating that the claims include specific features that were specifically designed to achieve an improved technological result. So we have our friend the word specific again coming back. Okay, so what is the consistent PTAB line of reasoning? I'll tell you right now that I believe they are applying something very similar to what gets applied in Europe, the European standard, which is your claim should be solving or should be a technical solution to a technical problem. And I think that if you can argue that your claim is a technical solution to a technical problem, then it will probably be found eligible by the PTAB if they follow these 6 cases in the line of reasoning. Otherwise, it will probably be found ineligible. And if you take a look at the graph or chart on the bottom, One way of thinking about this, and this is a graphic that I've been given permission to share from a couple of attorneys at Bold, Wade, and Tennant in the UK. And if you take a look on the left, the types of inventions on the left are improving machines. The types of inventions on the right are improving business processes, and the ones in the middle are improving people. And as you go from the left to the right, you start off with inventions that are more likely to be viewed eligible or as a technical solution to a technical problem, and as you move slowly to the right, they become less and less likely to be viewed as eligible. So that's something to keep in mind when you're doing your claim drafting or amending. All right, very quickly, the October update came out. I don't think it's really worth saying too much about. It clarified some of the minor details of the January update that were not particularly clear. I think that there's still some issues remaining about the confusing example claims, the prima facie case requirements, and the conclusory reasoning not being addressed. And that's something that hopefully the PTO will take up at some time soon. All right, so we are now at our second tracking poll, and we've got about 17 minutes left, if my math is correct. So please enter in the word abstract. I will pause very briefly so that you can do that. And once again, you can enter in the word abstract into the WebEx poll, either all capitals or lowercase or some combination thereof, or some word that seems like abstract or is synonymous to abstract. And we'll give you CLE credit because we want to be able to do that. If you enter in nothing, we can't give you CLE credit because those are the rules. We'll be back in about 15 seconds. All right. Since we still have a few things to cover, let's just keep rolling right along. So far we've talked about Section 101 with respect to what's been going on in the judicial branch, in particular in the Federal Circuit and then the Supreme Court. We've been looking at what's been going on in the USPTO. And in particular, we see that the Supreme Court doesn't seem to want to change 101. They apparently want to leave it the way it is. The Federal Circuit has struggled with coming up with a consistent interpretation of the Alice test. In fact, they've struggled so much that the PTO has come up with their own guidance that's different from their own examination guidance and their own Alice test, which is different from the Alice test being applied by the courts. And everyone has been screaming for Congress to step in and carry out what we call 101 reform and rewrite the statute and make it clear so that everyone knows what the heck is eligible and what isn't. Is Congress going to do that? Well, if you take a look at what I'm writing here, I think you're going to know the answer. And we're going to move kind of quickly through this because it'll be apparent why very soon. So if you take a step back and you look at patent eligibility, there's really two camps that are opposed to one another. There's the patent eligibility as broken camp, where individuals will say that the Alice test can't be applied consistently or fairly, and that it's just too hard to obtain and defend patents directed to certain types of software inventions, and also diagnostic methods, also certain types of business methods, and there's a bunch of other categories as well, and that the U.S. innovation economy is suffering as a result. But then there's this other camp that says, you know what, things are fine the way they are. There's fewer lawsuits from these bad actors asserting overly broad and vague claims. The cost of defending patent lawsuits has decreased, and the U.S. innovation economy benefits from killing off so-called bad patents, especially software patents. And so there's this tension between the two camps. They seem to disagree on these points. Now, back in June of last year, Senator Tom Tillis from North Carolina and Chris Coons from Connecticut released a joint statement saying that the U.S. patent system with regard to eligibility is broken and desperately needs to be repaired. The U.S. Supreme Court has confused and narrowed Section 101 of the Patent Act to the point where you just don't know what to invest in anymore. And this is really hurting our critical technologies and U.S. competitiveness. So that's a fairly strong statement. And so there was proposed legislation set forth by Senator Tillis's subcommittee. And I'm not going to spend a lot of time on this, again, for reasons that will become apparent very quickly. I just want to note that this proposed legislation would rewrite Section 101 It would also touch parts of Section 100 and Section 112. But most importantly, it would get rid of the notion of judicial exceptions altogether. So in other words, there would be no more abstract ideas, laws of nature, or natural phenomena. In fact, Section 101 would just go back to the statutory test, the 4 categories of patent eligibility, and there would be no considerations with respect to Sections 102, 103, or 112. So the goal here was to pull out the prior art and enablement and written description type analyses that are now being done under the auspices of Section 101 and take Section 101 back to the way it was intended by the 1952 patent statute. So that sounds all well and good. There were 7 hours of hearing on 101 reform talking about this proposed legislation in particular. And because I'm a masochist, I actually watched all 7 hours, and there were 45 witnesses from industry, academia, lobbying, and interest groups. I would say a majority were pro-reform, probably 75–80%. And they were concerned that there's a lack of patent protection in the U.S. in certain emerging technical areas such as machine learning and AI, healthcare, genetics, quantum computing, and other areas where you really would like the U.S. to take the technological lead like it has historically, but where it's struggling because other countries are patenting or allowing patents much more aggressively in those particular areas. There were also a group of anti-reform witnesses who essentially were stating that Alice is great because it allows you to get rid of bad patents quickly. And a bunch of other proposals came forth, maybe allowing 101 to go back to the 1952 Patent Act level of analysis, but then strengthening 112, or maybe allowing 101 challenges and IPRs. There's a bunch of stuff on the table. But ultimately, very little happened. In fact, nothing happened all of last year, and just in the last couple of weeks, we finally heard from Senator Tillis, who gave an interview to the IPO, and he basically said that the stakeholders in the 101 debate are just so far apart from one another and unwilling to compromise that he doesn't think that his subcommittee can do anything about patent eligibility anytime this year. So he seemed to be indicating that patent eligibility reform, Section 101 reform, was off the table for the Senate for 2020. On the other hand, Representative Hank Johnson, who is from Georgia, stated that, hey, this is a really complicated issue with a bunch of moving parts, and we're working our way through it. So he indicated that there's still some action going on. So it's kind of a contradiction. We're not sure who to believe at this point. There's either nothing going to happen or there's some relatively minor activity going to happen. If it were up to me to take a wild guess at what may or may not happen, I'm thinking it's probably not going to be anything happening because this is an election year, and in particular, Senator Tillis's seat is being very strongly challenged, and he might just not want to rock the boat and instead focus on other things like getting himself reelected. So I would be surprised if we have patent reform in 2020, but then again, I've been wrong before. All right. We have about 10 minutes left, and I'm going to switch over now and talk about best practices. So we've learned a lot from what the Supreme Court and Congress are going to do, or more likely what they're not going to do. And it doesn't look like the Supreme Court or Congress is going to fix 101 anytime soon. We've also learned that patent eligibility is being used as a shortcut for prior art and enablement analyses. And in fact, the Federal Circuit's test for patent eligibility is being applied inconsistently from panel to panel. It's all over the map, and you never quite know what you're going to get. And also we've learned that it's really not just software and business methods or diagnostic methods or genetics that are at risk of 101 difficulties. We're starting to see the 101 issues bleeding over into other areas of innovation that were considered 101 proof by at least some people before, such as charging stations, garage door openers, and manufacturing axle liners. So more mechanical and electromechanical devices that are clearly not abstract in any strict definition of that word are being found to be abstract or directed to laws of nature. So different bodies, whether you're examiners, PTAB judges, federal judges, are giving different amounts of weight to claims versus the specification. So let's take that all into account, and we'll make a few recommendations on what we can do as practitioners or as in-house counsel or as portfolio managers with respect to how we think about and handle Section 101. And I'm going to come up with a handful of do's and don'ts, which are my recommendations for how you deal with these issues. So first of all, do with claiming. Do recite specific limitations. Now, I mentioned this several times. The word specific shows up in Federal Circuit 101 cases all the time. So if possible, you want your claim to recite a specific function of a specific element that does something in a specific way to obtain a specific result. So there's 4 specifics there. The more you have, the better. You don't necessarily have to have all 4, but if you have none or 1, that doesn't look so good. If you have 3 or 4, that looks a lot better. Do include at least one technical limitation that's the best of your understanding is not in the prior art. So you want to explicitly claim something that's technical that you think is also novel. And by technical, I mean not business, mental, or mathematical. If you go back to the chart on the European test that I showed before, you want to be over to the left of that chart. Improving a machine, not improving, well, improving people sometimes is okay, but really you want to improve a machine. You don't so much want to improve people, and you definitely want to avoid the main goal of your invention being to improve a business. You also want to layer your claims with meaningful dependents so that you can argue your dependents separately. And I know this is a practice that everyone, knows from day one of claim drafting school, but it's really important with Section 101 because a lot of times what we see is a court taking a number of patents with a number of independent claims, picking one of those independent claims as a representative claim, and then doing the 101 analysis on that representative claim, and then either validating or invalidating all of the claims under consideration from that one representative claim. So if you have a lot of dependent claims with some real meat on them, you can argue independently for the eligibility of each of the dependent claims. And we saw at least a notion of that in the KPN case. Do not recite only broad or vague limitations. All right, we saw how that hurt companies like ChargePoint and American Axle. Don't focus entirely on features that fall into the 3 M's, math, money, or mental processes, because that's going to get you into abstract idea land very quickly. Don't explicitly recite mathematical or economical concepts if you can, and that's because the way that the USPTO is currently applying the test, explicitly reciting an equation will automatically get you at least further on down the Alice route that you don't want to go down. But if you can avoid explicitly reciting a mathematical equation or an economical concept and leave it a little bit more high level, that's good. And I realize that this actually seems to contradict the first bullet point, so there is a bit of a tension there, but it's something to keep in mind. Also, very important, do not rely on only outcome-oriented language. You want to claim how the invention works rather than what it does. You'll notice that a lot of the claims that are being invalidated by the Federal Circuit in the last couple of years have this outcome-oriented language that they're claiming the goal of the invention, not the steps the invention takes to achieve that goal, and that's problematic. Specification do's. Do describe in as much detail as possible the technological advance of the invention. Now, when I was coming up in patent law, I was told that you don't want to spend too much time talking about the prior art or why your invention is better than the prior art, because then the invention might be viewed as not having any other advantages, and you never know how inventions are going to be used in the future. And that certainly is true, but I think that those days are over, in particular because you almost need to do this in order to, in the specification, in order to convince a party, whether it's the PTO or the Federal Circuit or a district court judge, that you've got a patent-eligible invention. Also, you want to make it clear what cannot practically be performed in the human mind. So if your invention is claiming a very complex neural network that's going to be trained through thousands of iterations, make it clear to the reader that this is not something that can be performed mentally. It's going to have to run on a massive set of computers with a lot of GPUs for several hours or days in order to get any result whatsoever. If you have experimental results, include those. All right, life sciences people are really good at this. They often have experimental results. Those of us who do engineering type work often don't. But if you do, it doesn't hurt to include those if the applicant is okay with it, because a lot of times you can use those experimental results and point to them and say, this is our technical improvement. We've compared how our invention performs compared to the 3 best-known pieces of prior art, and we're 20% better in all cases, for example. And I've done this a few times, and it seems to be compelling to at least some examiners. Also, when you're writing your specification, assume a lower skill in the art than you would normally otherwise think, and you might need to just explain things in a little bit more detail because, again, examiners are not necessarily specialists. Some of them are coming from different areas, and so the more and judges, certainly would fall into the same category, so the more that you explain, the better off you are. Specification don'ts. Do not admit that most or all claimed features are in the prior art. This almost goes without saying, but surprisingly enough, a lot of 101 cases decided by the Federal Circuit ends up with a patentee losing because the specification describes what is being claimed as prior art. And they end up shooting themselves in the foot. Do not omit key technical details, even if you think everyone knows that. Be explicit about what goes into your specification. And don't describe the advance that the invention provides as an improvement to a human process or a business process. You want to improve a machine and not a person. Prosecution dues. When you're prosecuting a patent application through the USPTO, focus, if you get 101, 102, 103, and 112 rejections or some combination thereof, focus on 102, 103, and 112 before or while addressing 101. And you may find that by focusing on the prior art and enablement and written description issues, you end up addressing the 101 issues as well. Also, you want to argue 101 rejections both substantively and procedurally. The former, usually with claim amendments, is more likely to bear fruit, but sometimes procedurally you can just tell the examiner that they've not established a prima facie case, they've used conclusory reasoning, they haven't applied the test properly, and sometimes that will force the examiner or at least compel the examiner to give you another office action where they either withdraw the 101 rejection or they do a better job of applying the test. Argue each point of the test if you possibly can. Don't leave anything on the table. Argue the guidance to examiners in the PTAB, but cite helpful case law for the record, just in case your case goes up to a district court later on. Should your invention get patented, or to the Federal Circuit, it's nice to have that case law in the record as well. And of course, argue dependent claims separately. I think I've motivated that enough at this point. Finally, portfolio dues. You want to take advantage of the fact that you can file continuations and divisionals. This is really important with Section 101, and I know that a lot of sophisticated portfolio managers already know that continuation strategy is a big part of portfolio management, but you do want to plan on the initial patent of a family getting issued with narrower claims than you'd like if you're dealing with an invention that is 101 sensitive. In other words, software, business methods, diagnostic methods, genetics, various other types of inventions. Go for something narrow first, try to get something allowed, and then pick away at that and see if you can get something broader. Once you have an idea what the prior art is and what the examiner's thinking is, then you can focus your continuation claims and you can build up your portfolio that way. There's a lot of different ways and strategies of doing this. You can have picket fence claiming. You can have multiple independent claims with overlapping features, or you can just have multiple families covering different aspects of the same invention. And there's a lot more that I could say about Section 101 and best practices. Feel free to contact me if you have any questions, but good luck in your prosecution, in your portfolio management, and in protecting your inventions. Once again, my name is Mike Barella. I work at MBHB in Chicago, and I write for this blog called Patent Docs, and if you're into sarcasm, and I know you are, I posted 2 things last year on how the Federal Circuit's current application of the Alice test could be used to invalidate Edison's light bulb patent and Bell's telephone patent. And so if you want some mildly entertaining 101 analyses, feel free to go Google those. You'll find them on Patent Docs and read through those. I got another one coming up, another classic invention that I think the Federal Circuit, if they viewed it back then under today's test, could be invalidated, but I'm not going to tell you what that is yet. It's coming up in the next couple of weeks. You can follow MBHB on social media, learn about what's going on in our firm, articles that we write, and other things. And once again, thank you very much for your time today. Feel free to email me if you have any questions, and I'll get back to you as soon as I can. Thank you.